Any mention?
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 11. Your Lordship, I'm praying for 1 week's time. My deponent will be traveling to Shillong this week, Your Lordship.
No. You're appearing on behalf of
Of the
respondent?
private respondents 3 and 4.
Okay. Yes, on preamble. List after 1 week. Yes.
Obliged, Your Lordship.
Like to mention item number 6, my lords.
Yes.
Making a prayer for 2 weeks.
No objection, Your Lordship.
Repeatedly, you're asking time in this matter.
Oh, my lords, actually today I have some difficulty, my lord. The state was asking time, but today I have some certain difficulty. On the next day I will complete that.
Prayer to the petitioner, not objected to the learned GA. List after 2 weeks.
2 weeks, Your Lordship.
Obliged.
Much obliged, Lordship. May I please, Your Lordship? I beg to mention item number 5, Your Lordship.
Yes.
I'm praying for 2 weeks' time, Your Lordship.
You're appearing for?
Respondent, Your Lordship, sole respondent.
No objection. In the same order. 2 weeks. Yes.
Much obliged, Your Lordship. May it please, Your Lordship, I beg to mention item number 13. Your Lordship, there's other matters with a similar question of law, Your Lordship, which is still pending before this Honourable Court. Your Lordship, I'm praying all these matters may be fixed together.
My lord, this is local Yuktha matters.
Okay, these are-
13, 14, 15, 16, 17, my lord. These are all local Yuktha
So we'll come
matters.
after 2 weeks because other matters
The
proceedings are
arsenal
not.
orders column, my lord, we are waiting.
Okay, just one prayer made on behalf of the petitioner.
But my lord, these are different councils have filed. Different councils are represented petitioners, my lord. So my
Your
friend
Lordship,
here is
I'm for
13.
item number 15 and 16 also.
Okay, 15 and 16. Okay, 15 and 16, just say after 2 weeks on the
14.
prayer of the petitioner. Yes.
14 is Mr. Nongbri.
This okay. You see? You are mentioning 15 and 16, isn't it?
13, 15, 16.
No. Right now you are mentioning which items? You are
Item
there-
number 13, Your Honor.
You're in 13.
13, I'm for 13, 15 and 16.
13, 15, 16, 2 weeks on the prayer of the
I'm for 14.
So you have the same prayer. Do you want it to be adjourned? This also 14 also.
In item number
17.
15 and 16,
Yes.
there is an interim order also.
Okay. In the miscase, there is a,
Yes, ma'am.
okay. Just say list. Miscase you just say. Interim will stand extended. Yes.
My lord, this will be for 13 to 17, my lord.
Who is there in 17 and all?
17, Mr.
17 also, my lords, I am for the petitioner, my lords.
Okay.
Yes. And 17 also, my lords, there is a miscellaneous case.
Okay. Okay. Just see wherever interim order is there, that to be continued. Yes. Yes. Obliged, Lord.
Obliged.
Please, my lords, I beg to mention item number 3.
Yes.
The conducting counsel has some difficulties, my lords.
He always has difficulty. Mr. Kapi Bhattacharya. These are the allotment of shop.
No, Gudam,
Oh,
31 and 32. In fact, we had given him so many chances. Enough, I think. No more, I think.
Is there an interim order and all?
Interim order, he is continuing from the very beginning, 2019.
So interim order is still there.
Still there.
So we'll vacate it. We'll adjourn it.
Let the
My
interim
lords,
order.
just
forget.
a week's time, my lords. A week's time, my lords.
And no more adjournment, I think.
This is a matter. He is claiming right of continuance
Continuance, yes.
on the basis of the agreement exited by
Agreement.
his predecessor. Is it the case? It was heard at some length, isn't it?
It was hard at something. Then thereafter, he took time, he wanted to again give a representation. That was also rejected. We give him right to match, but he doesn't want to opt in.
So we'll give him 1 week time for just on the prayer of the petitioner. This is a matter for 1 week. This.
Grateful, my lords.
Yes.
Much.
My lords, item number 10.
Then nothing remains in the list then.
My
Yes.
lords, kindly list it after 2 weeks.
Yes.
No objection, Your Lordship.
No objection.
My senior is here, Your Lordship.
Your senior is here. Okay. Okay. Ah. He's not that happy today. Okay. Yes. When do you want it?
2 weeks, my lords.
2 weeks. Yes.
Grateful. Grateful.
You're there.
3 and 4 men. Private respondents.
Okay. But this is a matter between two brothers. You failed to settle it. Very bad. Yes.
All right.
Grateful.
Item number 1.
Wait, please, my lords.
Yes.
My lords, this is a revision application, my lords, challenging the order dated 29/6/2026. My lords, matter arises out of a Section 8 application of the Arbitration Act.
Arbitration.
My lords, what has happened here is, my lords, I had taken certain loans, my lords, from the respondents by executing certain facility agreements, my lords, as they call it. And my lords, that was okay. Now, because of certain financial crunches, my lords, there was some talk between both the parties, and there was a settlement agreement that was arrived at, whereby, my lords, the original figure of the loan was diluted, and a certain figure was agreed to by both the parties, saying that this is the amount of money you have to pay to settle this entire amount. I, my lords, paid the entire amount under that settlement agreement. That's the admitted position. Now, after I've paid the entire amount, my lords, they were required to release my pledges because, my lords, under the facility agreement, I had to pledge the shares as well as give personal guarantees. So I wrote to them, I said, please give my shares, give my personal guarantees, as I've repaid the entire amount under the settlement agreement. It is at that point, my lords, that the respondents, they said, no, we do not go by the settlement agreement as you induced us to agree, sign that settlement agreement. We do not agree to that settlement amount. Very well, my lords, you may not agree, you may agree, you have records in law. But insofar as I am concerned, my lords, the entire amount had been paid. So since, my lords, my money had already been paid, I filed a suit saying, my lords, that under the settlement agreement, this was the agreed figure, and this agreed figure has been paid by me. So they, by law, are required to now, my lords, hand over the original documents which are there with them. In that, my lords, they came and filed a Section 8 application.
That is a suit under specific release.
My lords. So, in that, my lords, they filed a Section 8 application saying that even though the settlement agreement does not have a, my lords, arbitration clause, the facility agreement, which was originally given to me, that had an arbitration clause. So, under that, my lords, arbitrator should be appointed. And who, my lords, as an arbitrator? An in-house arbitrator.
So settlement agreement basically is a continuation of that facility
My lords,
agreement.
I would not say, my lords, it's a continuation. I would say, my lords, it substitutes the facility agreements, because facility agreements then it becomes a precondition to, my lords, the settlement that is coming between the parties. The settlement could only occur, my lords, if there was a precondition saying that there indeed
But
there
then
was a...
you are saying that their plea is that there is no settlement.
No, my lords, if they say, my lords, there is no settlement, very well, my lords, then you are required under law to do certain actions. You are required in law to file some suit somewhere to cancel that settlement. That they are not doing till today. They have very well, my lords, taken more than 16 crores from me under the settlement agreement, which they say, yes, you have paid that amount of money, we've taken it. But we say that this is not the settlement amount. If you want to, my lords, backtrack from the settlement, the law is settled, your lordships are
But then
aware.
is it not that if court passes, court refers it,
My lords,
the jurisdiction of arbitrator, you can read, is raised before arbitrator.
my lords, my humble submission would be, my lords, this issue cannot be on the issue of jurisdiction. Your lordships are correct, my lords, that interplay would come into play, that interplay judgment would come into play.
Section 16 probably.
Lordships, that arbitrator would also have a right to decide on the jurisdiction of the arbitration itself. Your lordships are correct.
Section 8 application, if it is rejected, appeal lies.
Yes, my lords.
If it is allowed, no appeal lies.
No appeal lies.
Okay, we'll see. We'll see to it. Hard. This court basically is not equipped with the basic things.
We'll try and assist your lordships on, because there was your lordships are right, because there was some dispute, my lords, whether the arbitrator can adjudicate on these issues. Under Section 11, my lords, they say that you can, but when it emanates under Section
But
8,
in an independent suit,
my lords,
when a suit is filed
my lords,
without reference to any arbitration agreement and all,
my lords,
and that is for specific performance for
of a settlement agreement.
Now, if any Section 8 application is filed, whether the exercise of jurisdiction by the trial court would be deemed to be an exercise under the Arbitration Act.
Well, it's because she's acting under an application filed under
That is
Section
only
8.
so far as the application is concerned.
Lordships,
But then that way is transferring the jurisdiction.
I bow down.
No, we do not know.
I bow down, well, it's that.
See,
that
like you will be unwriting the court. with this.
well,
These
it's-
are the queries.
we'll
coming
try and
to
assist
court.
your Lordships on this.
It may be something because of ignorance.
Because
is
your
coming
Lordships
up.
had rightly said, I had filed for specific performance of a certain agreement. Which is that agreement? It is, my lords, the settlement agreement. Others do not become relevant for these purposes. That admittedly does not have a Section 8. Sorry, an arbitration clause. So if it does not have an arbitration
You
clause,
said
my
there
lords,
are some what is a facility agreement or something.
facility agreements.
Now, those agreement contained arbitration clause,
Yes, my lords.
and that arbitration was to be invoked in case of a dispute,
Lordships.
not for violation of any settlement.
No, my lords.
Anyway, we'll just sit with
My lords.
Mr. Paul or Mr. Paul, and a senior counsel assisted by
Mr. Thapa is on.
issue notice. Anyone appearing for the other side? How many respondents are there?
Sole respondent, my lords.
Issue notice returnable in 3 weeks. The petitioner shall take steps for service of notice upon the respondent within 2 days. Finished after 3 weeks.
Well, it's in the interim, your Lordships may kindly direct status quo because if an arbitrator is appointed, my lords, it will
Okay, we are
unnecessarily.
not passing any detailed order. We'll just suspend the order.
Well.
Okay, just for the time being. Just so petitioner shall take also. Then thereafter, before you say list the matter for 6. What is the order?
Well, it's your Lordships would find the order at page 380, my lords. It's dated 29/6/2026.
In the meantime, just say, in the meantime, the judgment order dated 29/6/2026.
Passed in miss case number 1 of 2020 by arising out of title suit number 3T of 2020. my lords.
You will find it at page 18 of the petition. Shall remain suspended till the returnable list after 3 weeks.
Highly obliged.
Item number
If
2.
it is an issue of law, maybe we can decide it on the next day on the appearance of the others.
We seeking some accommodation for the lordship. Give it such when it is.
For the Joy Municipal Board, respondent 7.
Give us about the something idea about it. We'll accommodate you. If you have difficulty, but so long you do not have difficulty, if you are there with you, then you will not need adjournment.
So, lordship,
Will you?
Lordship, I'm not conducting this matter. It's my colleague
It
and
may
his,
happen like that, we may not listen, Mr. Dev. We'll just decide on the basis of what you say. Can you tell us what is the subject matter? No.
Lordship, this pertains to parity, pay parity, lordship.
Pay parity. Okay. It's a complicated service matter.
Yes, your lordship.
You are claiming parity with whom? You are an employee of municipal.
Municipal.
Okay, and then you are claiming parity with?
Claiming parity with other municipal board employees.
Is it not that they are all basically guided by different acts, or they come all under the same? They are covered under the same, all the municipalities?
And they have their own.
So that your stand is that parity will not be applicable.
And here, my lord, our case is that this petitioner here, she was appointed as a community organizer under a central scheme.
Okay.
So whatever salary and all was drawn
Her
by
appointment
was
was under scheme.
under a central scheme, centrally funded
So
scheme.
not in a post created by the.
No, no. So that is why her representation was rejected.
That scheme is still prevailing.
Lordship, scheme is there, but scheme provides a cap for the.
Just a minute. Whether
provides
scheme is prevailing. It was a scheme meant to run for certain period of time, or it was to be continued.
no scheme is still there. Scheme is still there, but that very scheme provides for the salary. It's also she wants it according to the Meghalaya Pay Commission, which is applicable across the state.
No, that is okay. That is certain. Just let us know about the scheme.
Lordship.
Now, scheme is still in force. That was a post created by the scheme, and the provision of salary is also made in the scheme itself.
Correct, Lordship.
Now, he is paid out of the scheme.
That fund, yes.
Now, that would not make the petitioner an employee of the direct employee of the municipal.
Correct, Lordship.
Is it your stand?
Correct. We are. She is in fact appointed in on a contract.
Continue so long the scheme continues.
Correct.
Isn't
On a
it?
contract basis.
And her entire claims and benefits should be guided by the provision of the scheme.
Lordship.
That is what your stand is.
Lordship. Contract basis, 3 months extension as per the as when the scheme continues.
There is no selection process, nothing.
Nothing. This is a poverty elevation scheme by the central government, essentially. She is a community organizer whose job is to basically oversee these.
But then poverty alleviation has to be permanently, isn't it?
No, scheme is there. She is in service. She wants the pay scale under the 4th pay Meghalaya Pay Commission at par with all other municipals and state.
So, was there any scope of hike of salary in this scheme?
She has been given increments under the scheme. It's not that she has been stagnant.
So, there is a Pascal case scheme.
Yes. But it provides a cap of 10,000.
State is represented by? You are there. And what role the state plays so far as the implementation scheme is concerned?
She is an appointee of the joint municipal board. So the scheme is also being
Implemented.
Municipal board only implemented. My lord, we do have a role because the pay commission is mentioned here. But my lord, she is responsible for that.
The state role is
Insofar as the pay commission, my lord, and my lord, there are some communications will be having given the state, and state has written to them that her appointment, her services are being regulated by the municipal board now.
So that means the state stand is the state does not have any hand in it. I mean, like no rule.
Yes, ma'am.
So then parity, your claim of parity is on the basis of change of counsel. Anyway, we are so your claim basically of parity is on the basis of what? The other appointees in other municipal board, they are not appointees under the same scheme.
Yes, Your Lordship. However, they are under the same department, that is the Urban Affairs Department. Your
But then if your appointment is under the scheme, the appointment doesn't
Now, the
matter.
scheme also has been extended to a urban development budget, Your Honor, Your Lordship.
But that is
budget
okay,
is by
but you will
the
be entitled to all the benefits under the scheme. But then whether you can be equated with any other employee of the municipal.
as per Jagjit Singh, we are entitled to minimum pay scale, Your Lordship. Because their contention is that we are temporary employees, Your Lordship, and as temporary employees, we are covered under Jagjit Singh, Your Lordship.
Jagjit Singh, well, there was a matter decided in a division bench.
My lord, my lord was part of the bench. Similar issue was the same.
Yes, probably the judgment was delivered, that is concerning electricity board.
My lord, the NEC and police matter. We will be relying on that.
Jagjit Singh was done on the basis of the admission made by the other side. So there this is not a case of admission. Have you seen the judgment of that? What happened to that matter was whether further taken to apex court. It was not taken to apex court. So it has remained like that.
Yes, ma'am. The decision of.
So then we will be bound by that whatever is there.
So my lord, we will be relying on the judgment.
Moreover, there's no dispute whether our duties are identical to the employees of the different municipal board, Your Lordship. There's no dispute from their end as well, because we are serving the same duties, doing
If
the
you
same
are relying on
responsibilities.
Jagjit Singh is totally on the basis of admission. See the operative part of Jagjit Singh's judgment. Okay, you can have a look of also on the division bench judgment rendered by us. Have you come across that decision?
No, Your Lordship.
Just go through once. And then basically just
then I'll be allowed to examine the.
Definitely, definitely. You are allowing, you see, it is not that the court was not, court would accommodate you. But then court just wanted to get the idea about what is the matter. So issue is only that. Parity, claiming parity with other employees, employees of other municipalities.
Moreover, I was not granted the fourth pay benefits. I was not granted the fourth pay benefits, while the other staffs
That
in the
is, but then is it not a different cause of action? Or it is here?
this is part of my prayer, Your Lordship.
What is that order of 9/2019? We are seeking quashing of.
My representation was rejected, Your Lordship.
Letter, my lord, right. Page 55. That is his impugned, my lord. Impugn order.
The grounds of rejection of my representation was that there was no sufficient fund, Your Lordship.
Can it be a ground for rejection?
That is, in my humble submission, not the ground. But the ground is that the fund under this program is not sufficient.
But this fund has been extended by the urban development budget.
But the petitioner was receiving under the other scheme, a program under which he has been assigned the duty of community organizer.
What is the scheme?
That scheme is, my lord,
It's not on.
not on record, my lord.
You have to bring the scheme then. You have to see the scheme.
Moreover, in 2009, Your Lordship, I was given a pay scale, Your Lordship. In 2009.
Whether that falls under the scheme or it was.
No, that was communicated to the Urban Affairs Department and
Where is that
subsequently.
document by
12,
which?
Annexure 12, page 32, Your Honor, Your Lordship.
What is the difference of salary between you and the claim which you are making?
Very huge difference, Your Lordship. Other municipals are receiving more than 25,000, whereas I am stuck to 5,000, Your Lordship.
So your contractual appointment basically lapsed. It was over after 6 years.
But I've still
Isn't
serving.
it?
Yes, sir.
So then you were given new appointment in 2009.
Extended from time to time.
So 2009 you became an employee of the municipal, isn't it? Your appointment no longer remain at the scheme. Is it correct to say the Pascal which was prescribed,
Yes, Lord.
where from that Pascal was?
But the state have denied this, saying that there was no formal approval or no sanction. So they are denying this. The state is
That is
denying
okay,
this.
but then it is for the municipal to say
That is
that
for
where
the
from that prescribe was conferred on you. This must be this prescribe must has been prescribed somewhere in the rules and all, isn't it?
That was
They
in
cannot-
creation of the post, Your Lordship, on 1996. That was where the scheme was. That was where payment was made through the scheme, Your Lordship.
The community organizer, that is a permanent post or it's a.
It's a contractual
post.
My lord, may I have the page 20, my lord. That was the manner and mode.
No, then what is the purpose of issuing this appointment letter then? Just you see, very interesting. In the interest of public service, what is so and so, the community organizer of this board, who had been serving on contract basis, is appointed. That means that this gives an indication that that is after the contractual appointment is over, this has been given, or maybe the contractual appointment was terminated after 6 years and then regular appointment was given. That is what it means. Otherwise, what is the use of appointing a person in the same capacity which he is holding? If you say that the very post is created by the scheme itself, you have seen page 32.
This was also marked to the department. This was also.
And then the person, he was holding that post for 6 years, same post. Then what is the need of again issuing this order? Have you seen page 32, annexure 12 of the writ petition? Where is your initial appointment?
Initial appointment is Annexure 7, page 24, Your Lordship. I was appointed in 2002.
You are the sole appointee under the scheme, or
Yes,
there
Your
are some
Lordship.
others?
There was only one post, Your Lordship.
Okay. But then we need to see the scheme. In the contract basis with a fixed salary, isn't it? For 3 years or 3 months.
3 months, my lord.
But that has been extended from time to time.
On the same terms and condition?
Yes.
Where is the subsequent extension orders?
Extension, one of extension is page 28, Annexure 9.
Now, if that is the situation, at the time of your appointment, then page 32 brings about a change. It confers a pay scale on you
Yes, sir.
and doesn't give it an impression that that is on contractual basis. Yes, Mr. Deb, what you will say about that?
Lordship, on affidavit, they have not really clarified that, my lord, except to say that.
No, but then this is your order,
Lordship, yes.
page 32. There is your order, and it is for you. You have done it. Maybe the original appointment of the petitioner under the scheme, but then it seems like that the petitioner was shifted from the scheme and was given a regular appointment by this order under you. You may say that the name of the post remains the same, but then it is under you. Otherwise, who gave you the right to confer a pay scale?
Lord, my
If
lord,
you want to still maintain that this is the post under the scheme.
so we have to perhaps, on reading this, we have to take very specific, because it appears to be a little, my lord, amiss, because on one hand it says contract basis, at the same time it says 6.
It doesn't say contract basis.
It says, my lord, at page
Where is it?
32 also.
Who have served on contract basis, Your Lordship.
It is appointed in the.
Who have served is past.
Not very
Who
clear.
had served? It is not that. So at the time of issue of that, the petitioner had served 6 years. There is no dispute with regard to that.
Correct.
But then how do you say that this further appointment or the further continuation was on the contract basis?
Lordship, which is why I'm saying from the affidavit, it only appears that this. order was
your
rejected by the
letter.
government.
It is your letter. You have to clarify to us.
Lordship, yes, it appears, my lord,
Just
that.
tell us what basis you have given it. And definitely you must have paid salary under the thing, the scale, pay scale. What was accrued?
We are saying, my lord, that she has been receiving 6,000 only under the contract, never under the pay scale, lordship.
Which you explain that page 32.
Lordship, yes.
What is your response to this page 32?
Lordship, because
Now that becomes the crux of the issue.
affidavit is very, my lord, silent, unfortunately. Allow us to take some very specific instruction on
This
this.
is a old.
I appreciate, my lord, because this was. We have received the copies
No,
also.
it
very
seems that
recently.
the entire basis on which the petitioner was appointed, it was changed. Now that contract part is over with this appointment order. If you say that this further, now after this page 32, was there any order issued showing the extension of the petitioner under the scheme? No. So that means petitioner continued on the strength of the page 32. Then you cannot come and say that the petitioner still continues under the scheme. It is for you now to clarify.
Correct, lordship.
Just on prayer made by the
Affidavit is
party.
little silent. Allow us to take a very proper instruction.
You
on
just
that.
take, we will not say anything specifically, you need to take instruction and all. Now you know what is there. So at least parties will be, the next day we expect that you throw us more light
Lordship.
on that. Throw us more light on that, on those aspects. And what is your stand taken in the petition on page 32? That also you have to see. What you say in your petition, before we see what he says it is a reply. Just on prayer made with the parties, list of documents.
Lordship.
Yes.
Obliged.
Item number 7.
Yes.
Please, Your Lordship. Lordship, this is that electricity matter regarding DPC, Your Lordship. Mrs. B. Karwalang is handling this matter, Your Lordship. She's having some personal difficulties today, Your
So you will handle it today.
Lordship.
When she has difficulty, you will handle. When you have difficulty, she will come and she handle. That is how the lawyers work, isn't it?
Lordship.
Miss Conley knows it very well. So what is to be done here? This is a case where we wanted you to be. I think earlier Mr. Pandey had submitted there is a redressal.
My lord, they were supposed to
My lords, there is an alternative because
Yes.
this is a case, my lords, concerning disconnection.
Yes.
So there are already regulations in place. If they want, they can raise it before the appropriate forum.
No, that is
Lordship,
for taking
spare my
instruction only.
instruction, Your Lordship.
See,
There was some
useless keeping this matter pending.
the weak, Your Lordship.
These are all unnecessary burden on the court.
Lordship. I bow down, Your Lordship.
You see, your bowing down doesn't make any difference until and unless we are able to dispose it of.
Lordship.
This is a problem.
Lordship, after weak, Your Lordship. Lordship, as per my instruction, they have to bring on record.
Various other matters, my lords,
Lordship.
also of similar nature, have been sent to the grievance redressal forum. So
That is, you see, if they have a remedy available outside, why this court be approached?
yes.
And so far, if it is a dispute regarding the amount of bill, is it? Is it something like that?
Lordship, regarding the
Yes, my lord.
men of
Yes. Then which way REIT court can help it? Just tell us.
Lordship, I'm a little handicapped, Lordship, if the matter could
You
come
are
out
not
like-
at all handicapped. You know very well.
Lordship.
You are well armed, but then you know the capacity of your arm now. I see. Isn't it? Okay. After 1 week, we'll not give you further time. Yes, Mr. Pandey will have it after a week.
My lords,
I'll oblige, Lord.
After 1 week on the prayer.
okay.
Yes.
I'll oblige.
Item number 8.
Actually, this is a matter which had went for mediation. So it appears that it has failed. So it has
Yes.
come back again.
Yes.
It's for quashing of FIR.
Yes.
And for the private party, Lordship, respondent.
What is the offence involved here?
It is section 420, cheating and dishonestly inducing delivery of property, along with section 506, criminal intimidation. Your Lordship, this is a matter where, Your Lordship, the petitioner and the respondent number 3 was involved in a business transaction. The petitioner is from Meerut. So, Your Lordship, they had some business transactions. So now, Your Lordship, what has happened is that the respondent number 3,
There are objection by the state with regard to
we have objection, Lordship.
even the private respondent. You are also objecting to the prayer. Who is appearing for
It was Mr.
Joshi? Mr.
Joshi.
A. Joshi. He's from Shillong only, isn't it?
Yes, Your Lordship. They are claiming, Lordship, that the respondent number 3 is claiming that they have to, there's a default in payment of 10 lakhs, whereas the petitioner is claiming it is 5 lakhs. So there is where the dispute.
That is okay. What this court can do so far as
Lordship, a case
that
stands.
question is concerned.
A case
Isn't
stands
it?
in this case. That is a case.
No, but then we cannot decide the matter on merits in the absence of that party.
Absence, that is issue.
Why mediation failed?
Your Lordship, we appeared, but then it seems from the petitioner said they're not inclined to get
Okay. They're not.
settlement.
None appears for the petitioner. Oh, Mr. Thawar, Learned Counsel is present on behalf of respondent number so and so. And Ms. Medbul, Learned Counsel, is present on behalf of respondent number so and so. When shall we list it?
2 weeks, Lordship.
List after 2 weeks.
Much over.
18.
May it please your Lordship.
Yes.
Lordship, this matter, Lordship, I have heard before. I'd like to refresh your Lordship again, this matter. This is
regarding
pertaining to remission, my Lord.
Okay, remission of sentence.
Yes. This matter, what happened in the year 2024, 31st January 2024, I have filed my representation for remission of the rest of my sentence, my Lord. What happened? The state
You are
responded.
convicted for which offence?
302, my Lord.
Okay, and sentence for
For life, my Lord.
for life.
My Lord.
302 for killing 1 person, 2 person, or how many persons?
More than 1%, 2%.
Okay.
Then, my Lord, what happened? I filed my representation. It was kept pending for 1.5 years. And in the meantime, what happened on the 31st January 2025, a new policy came of the Meghalaya, NHF 4, my Lord. Of the,
Okay, policy remission, policy for remission, yes.
yes. So
Revision
this
of
policy
sentence,
came,
yes.
and by virtue of this policy, they have rejected my representation, my Lord.
Yes. So what is the wrong? What is wrong in rejection?
What happened? They have mentioned that
What is the rejection?
because of the
order?
double murder, remission cannot be granted, my Lord. By virtue of one of the clause they have mentioned is Annexure 6, my Lord. Clause C of the remission policy, which states that the convicts who are convicted for murder of 2 or more persons in one incident
Annexure-
or in separate
you're
incident.
reading page.
Page number 33, my Lord, Annexure 6.
Yes, that is the order of rejection. Yes.
My lord. So based on clause C, have stated that because of the double murder, this cannot be granted. This is.
So what is wrong in it?
My lord, my contention here is I have filed my representation in 2014, whereas the new policy which came in 2015, which cannot be applicable in my case because the representation
Why it cannot be applicable in your case?
because the Gazette notification, it says that this is implemented. This can be implemented from February after the passing of this. This is at Annexure 7, my lord.
Page
34, my lord.
Yes.
Yes. Here, the date of this Gazette notification is that 20th of February 2025, my lord.
Which part? Okay. Where is that notification? It refers many notification. Where is that?
My lord, before that, my lord, kindly come to page number 26, which is Annexure 5, which says that, may I read, my lord? Page 26, my
No,
lord.
no, you wanted to show some date on page 34. Now you are coming to page 26. What happened?
Yes. Yes, I'll come to that also, my lord.
Oh, but then you go one by one. You just
Yes.
cannot just leave one thing half done and come to
This is connected, of course, my lord. That is why this is.
Page 20.
26, paragraph 2, my lord.
Yes.
Therefore, the Governor of Meghalaya is pleased to notify the Remission Policy 2025, which shall come into force from the date of its publication in the
Yes.
Gazette of Meghalaya.
Yes.
And the Gazette of Meghalaya, which is at Annexure 7, my lord, which is published on February 20th February 2025, my lord.
Okay.
So, any policy or act which comes, which cannot have a retrospective effect. That was my.
No, where is it? Where is the in the Gazette notification? Where is this policy? Where is the reflection of this policy?
It is.
The policy has been notified by which notification?
My lord. Number PDS 23 stroke.
Where is in which page? In which page?
This is in Annexure 5. This is the policy, my lord. This is the number of the notification, my lord.
No, you said that has been notified in the Gazette of Meghalaya dated February 20th, isn't it?
Yes.
Now, where is that? Just show us, we do not see it. The first notification is about Water Conservation Department. Second one is something appointment somebody else is seeing. Where is that?
Yes, my lord, come to page number, the same notification, page number 35, my lord.
Yes.
35, it is written there, PDS 23, 2021, stroke part, stroke 564. This is the whole Gazette notification. It is quite bulky, that's why I have given only the relevant portion, my lord.
Yes, so what happens then?
So my plea is that, my lord, the representation which is filed in 2024, I cannot be governed by the
Then
by
you
the
are
policy
governed by
which-
what? You are governed by what?
I should be governed by the general principles, my lord. That is
Why should
that
there be
is
general principle?
432 of the remission policy.
It is not your case that there was another policy in existence at the time when you applied.
There was no policy. my
Then?
lord.
Then what is wrong in it?
Section it should be governed by section 432 that is mentioned under CPC, my lord.
432 requires making of a policy, isn't it? For this policy is independent of 432.
Yes, my lord. No.
Then You just give us some law that a remission application has to be considered on the basis of the situation which is prevailing on the day of application.
In fact,
When there was, admittedly, there was no policy in existence. Give us something.
in fact, the opinion of the judge, my lord, which says that he is touching his 70s, my lord, that there also he has stated that remission can be granted to this particular convict. But,
No, but then
this
if-
was also not considered, my lord.
See, if a clause in the policy says that yes, if you are involved in double murder, it can be rejected. So that is what is wrong in it.
My only plea is that this any law which is passed cannot have a retrospective effect which will violate Article 20, Clause 1 of the Constitution, my lord.
We have not
And
understood. You see, like this is a policy. Policy is not a matter of right. You see, remission is never a matter of right.
My lord.
So, where is the Article 21 coming here? Article 21 speaks about your fundamental right, isn't it? Now, remission is never a matter of right.
It is about Article 20, my lord.
Can remission be a matter of right?
Article 20, Clause 1, my lord.
What does it say?
No person accused, no person shall be convicted of any offence except for violation of law in force at the time of the commission of the act.
Come on,
charged as offence.
What you are bringing in? What? Show us remission. Remission's basis is something different. What is wrong in it? You do not understand. You might have filed an application sometimes where it was considered after politician came into existence.
This was kept pending
Just
for one.
give us a law specifically on that point.
My only point is that, my lord, which is my representation, which was kept pending for more than 1 year, in fact 1.5 years, that itself is illegal, my lord. That cannot be done. In fact, the new judgment of the Honorable Apex Court, which also says that it should be disposed of as early as possible, my lord.
Okay, then in failure to do so, what is the consequence?
In fact, my only plea is that I cannot be governed by the policy.
Give
which
us
came.
supported by law. Supported by law. Do not bring Article 21. Article 21 has no application here.
There is no such law. Only the judgment of Lakshman Nakskar and Union of India. my
What
lord,
does
that
it
is-
say? What does it say about application of policy?
This
The
says
policy
that
cannot have a retrospective effect, application.
no, it doesn't say that, my lord, but it only says that certain principles or guidelines which has to be followed while considering remission, my lord.
And what are the guidelines and which have been followed in your case?
It is first thing which has not been followed is the judge's opinion of the judge, my lord, session judge.
Okay.
So that
What is the opinion of the session judge?
Can you come to the affidavit filed by the respondent, my lord?
Now, where is the plea in your writ petition? Where is the ground raised?
My lord. About the opinion of the judge, which has not been mentioned, my lord, which came
then? Then if
affidavit
it is your
was-
ground,
the
you are
affidavit
see
was-
whatever ground you are taking, and then you say
This-
like it has not been mentioned.
this-
Whatever you are raising plea, you are not giving any supporting materials. Which we decide. Just tell us.
This opinion, which came later, my lord, this affidavit was filed much later, my lord.
No, but then you are
This
taking
is
it
a
as a
part of the
ground.
this is a part of
You
the
see,
record, my lord.
you are taking it as a ground, so that ground has to be there in your writ petition.
This is a part of the affidavit of the respondent, my lord.
So far as the decision of the judge is concerned, but then where is that ground taken in your writ petition? What is the foundation in your writ petition? That retrospective application of the policy. I think you need some preparation, mister. Please come with this thing, and then you're keeping just shifting grounds from grounds and all, but then you are not supporting any of the pleas by you.
In fact,
At
I
least
have
if you say that this policy should not have been given a retrospective effect, well, we can understand that that policy, that submission will hold field. Had there been any other policy in operation at the time when you applied for it? But then that is not your case.
there
Your
was no
case is that the time when you made the application, there is no policy holding the field. So subsequent the time of consideration, if it is done on the basis of the new policy, you just say if it is illegal in the law, then show us something.
to my basic understanding, my lord, when there is no policy, the constitutional power of the statutory laws, which is given under section 432, my lord, that will be applicable, and
The time when it is consideration, it comes up for consideration. So at the time of consideration, admittedly there was a policy and it was taken into consideration.
My lord, the gazette notification itself is very clear that it cannot be implemented before that, my lord.
We do not
2nd
understand.
February
See,
2025 is
whether
the-
this decision, your consideration came before the gazette notification or after the gazette notification? Consideration.
after that, my lord.
That is
after the
okay. That is good
notification.
enough. Now, if you want to say the term it is illegal, give us something, some law.
There is no such law, my lord.
Then what basis you will make out your case? Yes, madam, what you will say?
My lord, my short submission will be like, my lord, we have decided the application, the representation of the petitioner. His application is 2024, my lord, as per record, and we are not denying that. But Lordship has also pointed out that we do not have the remission policy at the time of the representation. Remission policy was subsequently introduced by the state
What about
government.
his contention that it could not have been given retrospective effect?
My lord, we do
You
not
should
have...
have taken it a decision on the basis of whatever the situation prevailing at that day.
My lord, in that case, Lordship will recollect that the matter was sub judice before the Supreme Court also since 2021 regarding the remission policy. Okay. There were writ petitions also been filed before this Honourable Court, but this Honourable Court has awaited the outcome of the suo motu matter before the Supreme Court. And subsequently, my lord, a policy has come into effect.
It is on the basis of the direction of the...
This is the judgment based on this, my lord, it has come.
So, my lord, Lordship has also led that matter as an additional Advocate General. Nabamtai was the first application, my lord. So at that time, my lord, we have filed an affidavit before the Honourable Court also.
Nabamtai was a case, there also an application was filed.
Remission.
Before there was any...
There was no remission. And my lord, an affidavit was filed before the Supreme Court in which a list of all the inmates who have already, my lord, they are languishing in the jail for more than 17, my lord, yet their lists were even put up before the Honourable Supreme Court. And that matter was sub judice, my lord, because very few state has actually introduced a remission policy at that time. So subsequently, my lord, with the direction and the observation, my lord, there were many analyses being made. Lordship will have the policy also. In that policy, the many judgments of the Supreme Court has also been quoted. So subsequently, my policy has come into existence as on today. So we have immediately take up all the matters. And
It is not only that this state,
my lord,
which has taken decision on the pending applications,
my lord,
on the basis of new policy, there are other states also similar situations.
Yes, my lord.
The states which did not have policy.
Yes, my lord.
So there cannot be any imputation of wrong then. So far as the taking of decision after the coming of the policy.
Yes, my lord.
There cannot be, isn't it?
Yes, my lord. That way, yes.
Because that was, we do not know what the Supreme Court decision says and all that. You will be knowing. This court has no knowledge about that. But then,
In my humble submission, my lord, we have a policy today. All the representation apart from this has also been taken up, my lord. And the fact remains that this person, this my lord, convict has been convicted for double murder, my lord. And the policy does not permit a person who is convicted of two double murders, my lord. So, my lord, on that ground, the application was also rejected, my lord.
now does it, whether the policy prescribes the manner of filing an application and all?
Yes, my lord.
Where is that?
My lord, as per the new policy, my lord, number one, my lord.
That is the only policy you have?
Yes, my lord.
If you say new policy, that means
No,
the
my lord,
only
as per our existing policy, my lord, I correct myself. Existing policy, my lord, after the petitioner need not file an application now directly, it has to go through the jail, the superintendent, my lord. And number two, my lord, after an application is rejected.
But then need not file, but then does it bar them from filing?
No, my lord, I don't think so, it should bar them.
No, but then if any application is filed, then what do you do?
My lord, it is immediately forwarded to the government, my lord.
Where is that? Where is that provided?
My lord, may kindly have page 29, my lord. That would be relevant.
Page?
Page 29 of the writ petition. That is a procedure to be followed, my lord.
Procedure to be followed.
My lord.
Yes.
So, my lord, number one clearly says that the superintendent of the district prison and correctional home, my lord, they have to ascertain which convicts are eligible to be forwarded, my lord. And then once, my lord, they are identify. Number two says that the convict can, this applications, the convict can also apply, my lord, through the superintendent of police. So they have to identify first, my lord.
Does it deal with the situation about the existing applications at the time of the formulation of the policy? Anywhere that the person, those who have applied before the policy is coming into force?
No, my lord, I don't think so. I've come across that.
And which way that situation is dealt with? So supposing at the time of, now, if you see the procedure prescribed here,
yes, my lord,
it says that when any application is received, superintendent of prison shall within 15 days of receive such application,
yes, my lord,
forward it. Okay.
Yes, my lord.
Now, the time when this policy came up,
yes, my lord,
admittedly there were some applications pending.
Yes.
Now, which way those applications were to be dealt with, where it is provided?
My lord, in my humble understanding is immediately once the policy came into picture,
whether there is any specific provision here dealing with that situation, pending applications?
My lord, specifically, I don't think so. I have come across that. Not with regard to lordship's query, my lord, I have not come across that.
Can you have instruction with regard to that, Ms. Colony, that which way those applications, pending applications were to be dealt with at the time of coming of the policy?
My lord, I can have a word with the department, my lord. I can have instruction.
Just to make the court know,
Yes,
to understand it more.
Yes, my lord.
Because so far as the policy is concerned, there is nothing.
Yes, my lord. But my lord, as far as what the procedure has been followed is that immediately went the concerned officials who were given to power under this remission policy sentence review committee, my lord. So all those applications which were pending were immediately taken up. And if I'm not mistaken, my lord, they are sitting on 6 months basis, 6 or 7 month basis, my lord, reviewing and asking for applications and any pending reports from each of the district jail, my
There's
lord.
a review, sentence reviewing
Yes, my
committee,
lord.
isn't it?
So sentence review committee is monitoring it. Otherwise, my lord, we have the honorable court also High Court is
okay.
also having a committee.
Just we are confining. We do not want to know everything about the policy right now, as we are not dealing with you see like a PL kind of
Yes, my
situation
lord.
here.
The procedure
Now,
that
only
is
thing
what they're
that
following.
we are just trying to deal with the contention of the petitioner, though it's not very convincing. But then since a plea has been raised,
Yes.
that his application was filed before this policy came into existence. Now, it gives an understanding that his application stood forwarded before this policy came into
Yes.
Now, whether those were considered as it is, or they were again asked to file fresh application, or on what basis? Now, that is what, if you can just give us some idea. Where is that clause which says that a person involved in double murder should not be, for a murder of two or more than?
My lord, page 27,
Yes,
my
yes,
lord,
yes.
CA.
Yes, there is a clear-cut provision. There is nothing wrong in it. Yes.
My lord, even if...
I've gone through it, my lord.
Say like the laws. TADA doesn't exist now. Does it exist?
No.
Now, even for consideration of remission, a person who is convicted under TADA has to be in terms of this policy. So, how do you say that this cannot be applied retrospectively?
My lord, even if the policy came in 2025, my lord, if we see the sequence of the applications which the petitioner has filed, my lord, he filed the application in January 2024. That is at page 24 of the writ petition. So subsequently, in the month of March, my lord, because we have to take the opinion of the district and session court from which he has been convicted. So, my lord, thereafter in March 2024, opinion of the district and session judge was sought, my lord. And subsequently, my lord, the district and session judge reports come to the state in October 2024. And there are, my lord, subsequent in January, the remission policy come into being. So, my lord, this was in a synchronized manner, my lord. Everything was being in a properly ordered manner.
That is all right. That is all
So
right.
there
But
is
then
nothing like it cannot go retrospectively. And apart from that, my lord, as I said, the matter was sub judice also.
see, according to him, you see, if policy comes upon a particular day, then the benefits or the disqualification criteria or rejection criteria formulated therein should apply prospectively, not retrospectively.
Yes, my lord.
Retrospectively. That is what his plea is.
Yes, my lord.
Now, his case is that even if you may have a policy of rejecting an application of a convict who is accused of who is convicted of double murder,
Yes, my lord.
but then that policy you cannot apply it to his case because that policy was not in force the day when he applied.
Understood.
You got the
I
thing.
understood, my lord.
Now, which way you deal with that situation?
My lord, in that case, my only submission will be, my lord, the district and session judge opinion was taken into record, my lord.
No, but then you see whether that ground which you have taken that stands or not. We are not confined with this thing. See, madam, you have to support the ground which you have taken in the impine order.
My lord.
You cannot
Yes.
enlarge.
True, my lord.
Okay, it or supplement it by some other reason.
My lord.
Okay, that is what the law is. Now, if you have to stand by that clause C of the policy, then you have to convince us that it was applicable on that day.
My lord, in that case, then my friend has to challenge the order of rejecting the remission, my lord, because he is not challenging the order of rejecting his.
Has it not been challenged?
My lord, he is
Yes,
only
remission has
the
not been
prayer of
challenged.
the prayer in the writ petition is to consider the representation dated 31st 1024.
No, it cannot be.
Yes, my lord.
My lord, this was raised in the last occasion also. And,
So, my lord, he has not challenged this order, my lord.
this was not mentioned in the prayer, but then it was only in the paragraph, my lord. That was raised in the last occasion.
That is not the prayer before this honorable court, my lord. The prayer is to my lord, to dispose of the representation, my lord.
So if that is be done, then
We
you
have done
to,
it, my lord.
You have to change your prayer. You have to amend your prayer.
In paragraph 9 and 10, which is mentioned to set aside and quash the letter dated 19/6/2025.
So there is not in your prayer.
No,
my
not in
lord.
the prayer.
So he is very well aware of the fact that his application has been rejected, but despite so, my lord, he makes a prayer that his representation should be again, my lord, be considered. So there cannot be second time, my lord. In my understanding, we cannot consider the same application twice, my lord.
It was mentioned in his paragraph 9, 10, and 11 only, my lord, and not in the prayer.
If his prayer is disposal, it will be disposed. There will not be second time disposal.
That has already been disposed.
And he's aware of the order. So he shouldn't challenge.
To take adjournment there to reply on the next day. There's the representation.
Yes, Miss Colleen. Oh, yes, Mr. Shula is also. We just give us all that thing. Like which way you dealt with the pending applications after this policy came into force.
Lordship, may it please your Lordship. Lordship, all application has to be dealt, your Lordship, after coming to force the new policy, your Lordship. That has to be done accordingly in terms of that policy, your Lordship.
His prime contention here is that the provision of the policy, basing on which it was rejected, that person convict who is involved in double murder, has become imperative only after policy came into force.
Lordship, kindly
that
see.
Policy was not there at the time when he applied.
Lordship, there was no policy, your Lordship. There was no policy.
All right, but then that particular clause, then in such a case, you should have proceeded strictly under section 432. And if you go by 432, then the opinion of the judge matters.
Is necessary, your Lordship. I have judgment on that also, your Lordship. I have
that is
judgment
all
on
right.
that.
Now, just clarify on that part.
Lordship,
Just
before entering to the merits of the
We are
petition,
not going into the merits and all. Just satisfy the court on that part. Whether you do it now or you do it later on these things, the consideration of application before policy came into force in terms of the provision of the policy,
policy,
the legality of it.
Law.
That is what we want.
Lordship, before entering into that arena, if Lordship kindly have the prayer made in the writ petition.
We have seen that Miss Colony has pointed it out.
Lordship.
We have seen it.
Because that representation
And
has
for
already
for the
been...
time being, we are not going by that. Taking into consideration, since it is an application for remission, and there is no matter of right involved, isn't it?
Lordship, yes.
It has to be on the basis of the policy of revision. The only thing is that what we need is clarification on that part, that admittedly the time when he applied
There was
for-
no policy, Your Lordship. There was no policy, Your Lordship.
Policy
And-
came later.
Yes, Your
But
Lordship.
this-
And this
at the
policy
time-
also came into...
At the time when it was considered, there was a policy holding the field.
There was no policy.
No, at the time when it was considered. Application was
Or,
considered.
Lordship, yes. At the time when his case has been considered, there was a policy.
So just satisfy on that the policy could have been applied to applications which are pending even prior to the coming of the policy.
Lordship, and then I'll...
Just say
Lordship.
that is why we
I'll
wanted
clarify in the next
Ms.
detail,
Colony to know that which way those pending applications are dealt with. Though we can understand that thing because apparently the time when he applied, there was no policy.
There was no policy.
So
Then
that way, his application is taken up later when the policy came. Rejection by as per the provision of new policy will not be illegal. But even then, since a plea has been raised, let us see if you can.
Lordship, yes.
In fact, my lord, just 2 months back, one judgment was passed by the Honorable Apex Court, which says that the nature of offence cannot be the sole ground for rejection of the remission.
Then you have to challenge the policy. Then you challenge the policy.
There is a
I'm not
policy.
going to that aspect, my lord. I'm just.
No, if you want to
sticking
say,
this.
you are pointing it out. If you say, you see, that is not a question of nature. Double murder is something else. And
In fact, for double murder also, I have.
it is the degree
Anyway,
of
I'm not going to-
heinousness involved.
I'm not going into all that aspect, my lord. Since my representation is.
You see, but we do not know. But then one thing has to be remembered that, you see, remission is not a matter of right. So that is what we do not know. Subject to, if you show that yes, now it has been included under Article 21, then
No, yes, sir.
his effort was there. Only he was trying to do that only.
My only thing is that, my lord, 20 clause 1, which says that retrospective effect cannot.
Come after 2 weeks, Your Lordship, then I'll reply on that point accordingly, Your Lordship.
Yes, prayer of District Attorneys. Just
Apply, Your Lordship.
throw. That law cannot be given retrospective.
Yes.
You see, until and unless it's a criminal law and service law, giving benefit to the accused or the incumbent, then it can give it. Otherwise,
Because this policy also came into
No, that is what Ms. Colony
Lordship,
has,
because there was a sumoto writ petition before the Honourable
yes, that is
Supreme
what
Court,
she
Your
has informed. Ms.
Lordship,
Colony
yes.
has said.
And then subsequently, Your Lordship, there was also a PIL before this court, Your Lordship.
Now, what has been informed to this court is that there are many other states which did not have policy.
Lordship, our state is one of that's
because
those
of
states.
that case before the apex court,
Lordship,
policy
yes.
came into existence. And in all the states, the pending applications were decided by applying the policy.
New policy.
So that is where. So if you can show that, you have a decision of the apex court. Dear.
This is the PIL.
That matter where the policy thing is to give.
Yes, direction
Okay,
is given.
okay, we'll just-
Direction has been given to the state governments to
Okay.
notify the policy
Please,
within
please,
2 months
try to-
from the date of.
Go through it. Try to find out something.
You have extra copy?
Yes, sir.
Yes, we'll see on that.
Lordship. Highly apply, Your Lordship.
Highly obliged.